Hello, thank you all for joining today. My name is Bianca Simmons. I am the Pro Bono Programs Coordinator with the North Carolina Bar Foundation. Today we have with us Elizabeth McKee, who will be presenting on protecting your business in contracts, a real-world guide for entrepreneurs and small businesses. Elizabeth is the General Counsel for Static Control Components and has been with the company for more than 15 years. She has played an integral role in Static Control's Landmark, Lexmark, and Canon cases. In addition, she is the Secretary of Council of the North Carolina Bar Association Corporate Council and previously served as the chair of the Corporate Council's Membership Committee and co-chair for the Legislative Committee. McKee received her JD from Syracuse University and her BA in International Relations and Political Science from Mary Baldwin University. I will now pass it over to Elizabeth. Enjoy the presentation and please feel free to ask questions throughout the webinar and we will answer at the end.
Thank you so much for that great introduction. And thank you guys for joining. And what I wanted to say just first off is I'm a general counsel. I've been a lawyer now for, I'm going to date myself, at least about almost 2 decades total. So I can honestly say I've seen a lot and I enjoy doing things. It's in the corporate context, but I also have a side passion. You saw my LinkedIn profile, and that is I taught adjunct faculty for undergraduates in law as well. So I've taught a whole host of different classes. And what I would tell you is that I do like participation, but I don't call on people. So as we go through this, I wanted to bring to you guys, as the bar was looking for a way to help, small business owners and entrepreneurs, I wanted to bring to you guys different ways that I can see that contracts can help your business. Now, part of that is really starting off with what is a contract, right? So I'm going to go over kind of our agenda and we can talk through what we're going to go through. So let me get linked in with the Zoom so I can get you guys all up and going and you can see my screen. And if at any time you have a question, 100%, please stop me and let me know. Okay. Are you all able to see this? Bianca, are you able to see it?
Yes, I can.
Okay, I just want to make sure. All right. So the first thing I wanted to talk to you guys about is what are we going to talk about today? What we're going to talk about today are basically what I call your contract basics. This is everything from formation of a contract, performance of the contract, and then what happens when you have a bad breakup, or you just kind of naturally go out. Then I want to bring that in with that foundation about what kind of contracts are going to be common for your small business and what ones, I'll talk about them in general, and then I'll kind of focus more in on a few because we only have a certain period of time. I'll focus more in on a few that I would say kind of are going to be the nuance of your business. And then I'll take questions again throughout and also as we move forward. So your contract basics, and while everybody thinks they know what a contract is, you'd be surprised at how many times we get involved in litigation where someone says, I had a contract, somebody else says they don't, even when it's written on paper, right? So it's basically a legally binding agreement between 2 or more parties. Getting into this, everyone thinks, all right, what do you need to have a valid and binding contract? This is going to be your offer, your acceptance, and your consideration. So what I'm going to do is kind of step back from that, and I'm going to break it down for you because there's special requirements for each one of these elements that have to be met. The first thing you have is an offer. Okay, an offer is a promise or commitment to do or refrain from doing something specified in the future. So what does that mean in non-lawyer, barren law book speak? That means a clear promise to be bound to do something on the condition that the party accepting the offer will do the same thing and something for you in return. So what I have here is someone will say, I have made this offer, and then someone will say, well, I accepted it. Well, that's why we need to talk about what the valid offer is. A valid offer requires that the offerer is intent to be bound by the terms, that they must be clear and definitive in their substance. We'll talk about that in a minute, and it has to be communicated. So many times people will think that they've made a valid offer, but it might not contain all of the required terms. It needs to have a specific subject matter. It needs to say what the price is, what the quantity is, and when the time for performance will be. So you have to also then make sure you're communicating this effectively so that you can ensure that you have a valid offer. Does anyone have a question before I move on? Okay. The next part really comes down to acceptance. And what I want you to remember, because I don't know all of your businesses and what levels you're at, or what your level of revenue, if it's something you're just starting up. You can have oral offers, you can have written offers, all different kinds of things. But the basic thing I want you to remember is that to have a valid acceptance, you have to use what I call the mirror image rule. It's not just me, it's a whole lot of people, but the mirror image rule basically says it's a clear manifestation of the agreement to the exact terms in the offer and in the manner specified in the offer. Okay, so when we talk about a counter offer, that basically cancels the outstanding offer and then turns around and makes a new offer. So let me give you some examples, and we're going to walk through this. As we do this, I want you to remember there's two types of contracts. There are unilateral contracts and there are bilateral contracts. The easiest way to remember this is that a unilateral contract is an agreement that can only be accepted by the offeree actually doing the required act. So if I'm the offeror and I'm posting a reward for my lost dog, I agree to pay you $200 if you find my missing dog. The only way you can accept my offer is if you actually find my dog, and then I'll pay you $200. If not, you don't find my dog, then I don't have to pay you anything. On a bilateral contract, this is an agreement that's characterized as a promise for a promise. So think of like a sales agreement. I'm selling my car. You agree to pay me a certain amount of money in exchange for the title to the car. I agree to deliver you the car title in exchange for that specified sale amount. Now, each one of these, talks about, I think we missed the slide. There we go. Each one of these talks about me accepting those terms or you accepting those terms. The first one is my reward for a dog. And the second is the car contract, the mirror image rule. Your acceptance has to be exactly the same as the offer. So let's go back and say, let's go to the car example. If I say, I want to sell you my car for, $700. And you come back and say, that's great, but I really only want to pay $5. You have just canceled my offer. You can no longer accept that offer unless I make it again. And you have issued me a counter offer. So our roles reverse. I now become the offeree and you are the offeror. Does anyone have a question on that? Okay. Now you get to the consideration. And this is something a lot of people don't really understand, or they think they understand. And it's very important when you're talking about this that you're very specific. So the last part of any agreement, you're having this meeting of the minds, the consideration has to be exchanged between the parties. Okay. So in the case of the car, the consideration is if you took my initial offer, it's $700. You're going to pay me that consideration for the car. Or in the case of the counter offer, if I accept your offer, you're paying me $500. That would be considered the consideration. Now, in the consideration for the unilateral contract with the dog, the consideration is the money once you deliver the dog to me. Okay. Now, there are some contracts that are required to be in writing to be valid. And depending upon your business, whether it's services or goods, it is going to be there might be things that will attend to it. In North Carolina and in the US in general, but then each state has their own, what we call a statute of frauds that requires some agreements to be in writing to be valid. These are promises to pay the debt of another, agreements of an executor or administrator to pay the debts of another, contracts that can't be completed within a year, a commercial loan commitment by a bank, savings and loan association, or credit union of $50,000 or more. And then under the UCC, which North Carolina has adopted its own version of the UCC, it'll be your sale of goods for the price of $500 or more. So for instance, going back to my car example, either one of those would have to be either my original offer at $700 or your counter offer at $500 would have to be in writing to be a valid transfer. So let's take this a step further. What happens if you believe you've created this valid contract and then all of a sudden that's not the case anymore? There are defenses to valid contracts. These are basically what I like to call your getting out of there card. Okay. So if any of these come up, if there's a capacity issue, if the court judges that the capacity of the person at the time the parties entered into the contract, they were either mentally incompetent, under the influence of some intoxicating substance, or they weren't of legal age to enter into that contract. Now, remember, there's different ages. So for some states, you can be 16 to enter into the contract of marriage. In some states, you have to be 18. Okay. So all of those things, you can have a capacity issue. If it's an illegal contract is the subject matter of the contract is prohibited by state or federal law, making it void. You see this in a lot of states now where you're dealing with whether or not, for instance, certain substances are legal or not legal. And if you have a contract for an illegal substance, then that contract would be considered an illegal contract. You also have fraud. Now, people usually think that they know what fraud is, but let's break it down. This is where a party is induced to enter into the contract based on the intentional deceit of the other party. So the party asserting this is saying, you had the intent to deceive me. The deception concerns material facts about the subject matter of the contract. And I justifiably relied on those representations that you made, and then I was harmed. You have to have all four of those to be able to show a fraud case. Going into the next that you see there is rescission. This is where the contract is canceled and the parties are turned into the positions that they were in before the contract was made. So say I take the car back that I sold you and I give you back the money you paid me. That would be an example of rescission. You have undue influence. This is the exercise of duress, which we'll talk about next, on one party by another who is closely related. That's the key there. So your undue influence is going to be someone who's in a trusted position, right? This could be not, an elderly person. This could be, a lawyer taking advantage of a client, any kind of those things, someone who's, any kind of undue influence. Regular duress is the exercise of pressure by coercion or threats to form a contract, right? Someone is threatening you that you better sign this contract, or else. Those are the types of things. Then you get into promissory estoppel. Okay, this is where a promise in which the promisor should reasonably expect to induce action or forbearance. I'm either making a promise, I'm doing something that's going to cause you to do something or not do something, creating a binding promise on the part of the promisor. So the party asserting the promissory estoppel has to prove, much like you do with fraud, there was a promise, there was a reliance on that promise, and there was an injury caused, but they also have to show that there's an injustice if the promise is not enforced. Okay, promissory estoppel is more of a ethical type of defense. Then you have your normal breach of contract, right? So you're probably saying, how is breach of contract a defense to a valid contract? Well, you say, well, this side already breached, right? This other side already failed to perform one of the obligations and they don't have a valid legal excuse. Therefore, I don't have to continue with this contract. And then last but not least, it's the impossibility of performance. This deals with death, destruction of the subject matter of the contract, changes in law making the contract performance illegal. So for instance, say we've signed the contract, I'm about to go meet you to exchange the money and the title, and I'm on my way there and I get in a car accident and my car is obliterated, okay? we no longer have to go through with the contract. So those are your defenses to valid contracts. These are going to come up in every kind of situation, whether you have an oral contract, whether you have a written contract. All of these things can be brought up. And you'll often see some of these addressed in some of the terms of written contracts where they've tried to handle these things up front by making representations and warranties that, me as a signor has the capacity to do this. I have the authority on behalf of my company, all of those types of things. Any questions on the defenses to the contracts? Okay. All right, so let's go with remedies. Basically put them in, there's a lot of different remedies, and I didn't want to get us bogged down into those because I want to get more into the meat of what we can discuss that might help you guys in your specific places. So remedies, we have damages, specific performance, and injunctions. Okay, so damages, these kind of roll into 3 big avenues. These are going to be your compensatory damages. These are actual damages that are equivalent to the loss a party suffered. So for instance, if I have a house and my house, you come over and you burn my house down, my immediate actual damages would be equivalent to the loss of my house, right? What was in it, everything like that. If I have consequential damages, right? These are going to be indirect damages. This is, in this case, me having to go stay at a hotel because you burned my house down. Or if it's in a good situation, this might be, say you're delivering some product to me, I am waiting on it, you don't, get it there in time, and I'm having to hire someone else to make the products that you failed to deliver in the interim. Then you have liquidated damages. These are usually used in a contract that allows for the payment of a specific amount should one party breach the agreement. This is where you're not quite sure going into this arrangement how the damages would pan out. It's kind of, I'm not really sure. You can see these a lot of times in agreements with tech. You're not really sure what the actual damages will be. So you might see all of these clauses together. Oftentimes people will try to accept out and have limitations on damages dealing with consequential and liquidated damages because they say, I would not be able to foresee some of these things that you're now alleging. Going with specific performance. This is an equitable remedy requiring exact performance in the contract. So let's take the example of a house, okay? Say we go through a sale, you purchase a house from me, and then I'm like, you know what, I really don't want to move. Well, you can go to court and the judge can order a specific performance. And this is, look, you've been paid the money, you need to move out, turn over the title and the house keys on this date. So that would be an example of specific performance. Then you have injunctions. This is a court decree ordering a party to do or not to do a specified thing. In the context of where I see this in my business is you're not allowed to sell a product. Say, you mentioned in the beginning, Bianca, that I am been involved heavily in certain cases with OEMs, right? So just to give you kind of a brief background on me, guys, now that we've gotten into some of these contracts, I'm the general counsel for a company named Static Control Components. Things that we sell, my elevator pitch is if you've ever used a non-OEM, not a Lexmark or a Brother or a Canon or an HP printer cartridge, it probably has my technology in it from my company. We have contracts with all kinds of aftermarket folks, and we are an aftermarket supplier of new and remanufactured cartridges as well as components. So, when we're in dealing with, cases, and for instance, ones that she mentioned with Lexmark and, Canon, courts will, a plaintiff might say, you're infringing on a patent or a copyright or anything, right? And they can go to the court and say, I want a temporary and then a permanent injunction on them being able to sell any more products because I say that they are infringing my IP. And oftentimes the court, if they make a good enough case, will say, okay, everybody hold up, or they'll say, nope, I'm sorry, OEM, you haven't done enough, and we're going to allow them to continue to sell, and we'll see what happens, and we can work that through on the damages end. So those are just some examples of things that I deal with. Any questions on the remedies? Okay. All right. So here's really where I wanted to spend the main focus of our time together. And this is really what I call the common contracts for your business. And I'll be honest, as I tried to put things into categories for you and say what's really going to help people, not knowing everybody's backgrounds, but just trying to do more of a broad brush. I wanted to bring in, and I'm going to touch on some things, and then we can always, if you have questions, we can address those. If there's things you'd like to see in some kind of follow-up session, I told Bianca I'd be more than happy to do anything like that, anything that'll help everybody out. So these are what I call your behind-the-scenes contracts, okay? These are your legal entity formation documents, your insurance contracts. You have, depending on the size of your company, you're going to have some form of property insurance. You're going to have, probably maybe renter's insurance or owner's insurance. You're going to have liability insurance. How big you are, you might have health insurance, right? Then you're going to have banking and credit agreements. You're going to have employee agreements. You're going to have probably marketing platforms that you're using to then market your products, or websites and domains that you're engaging with. You're going to have accountant and payroll providers, right? So you can make sure you pay your taxes and you can pay your employees. And, you'll have even such things as software licenses. The very, thing we're working on right now today is Zoom. For instance, my company uses Teams. You're going to have different software licenses with different entities to be able to use your products, whether it's an ERP system or just, Microsoft Office. All of those, a lot of these things people think aren't even contracts, and they aren't necessarily always negotiable, but there are things that you're entering into all the time. And if you go back and you look at, what we've talked about with offer, acceptance, and consideration, you can look, for instance, at your, your banking and credit agreement, right? You have an offer from the bank. They say, we'll loan you this much money. You accept that offer. Okay, you loan me this much money and I'll pay it back. And then that's the consideration. And then you have it signed, right? Because it's over $50,000 and it's with a financial institution. So all of these things, whether you've known it or not, are working through these different things. Software licenses are the same thing. You see a lot of end user license agreements. You can use the software. You have to pay us some money, and you have to promise that you're not going to do X, Y, or Z with this software. You're not going to copy it. You're not going to market it as your own. All of those kinds of things. But this isn't really where I'm going to focus today. I'm focusing more on the external and what you would be using to try to help protect you. These are things that you would definitely want to look at, have reviewed, and know that what you're getting into so you can protect your business. But a lot of times they're very take it or leave it, right? They're not really things that you're able, minus the employee contracts, not things you're necessarily able to negotiate that much. Anybody have a question on your behind the scenes contracts? Okay. So what I wanted to get into with you guys are things that are bread and butter, everyday business. Then some of this might be too simple for you. Some of it might be right where you are. And some of it might seem like I'm not there yet. So what I'm going to kind of do is walk us through that spectrum. So the first thing I wanted to talk to you about were invoice and purchase order terms and conditions. Then we're going to talk about sales and vendor agreements. I'm going to talk about waivers of liability. And then I'm going to talk about confidentiality and non-disclosure agreements. All of these are pretty much like the 4 areas I thought most businesses need at least to have a generalized understanding of, because they touch and impact how you purchase things for your business, and then also how you generate revenue for your business, and then how you protect your business, as well as how you protect your confidential information. So let's get started. And I am going to take a sip of water, guys. So first off, let's go through invoice and purchase orders. So a lot of people think that they understand an invoice and a purchase order. And what I want to do is I've set out here basically what they are, right? Purchase order is a commercial document, and it's a first official order issued to a buyer by a seller, issued by a buyer to a seller. An invoice is a commercial document issued by the seller to the buyer at the delivery of the product. And where people kind of go sideways is, they don't understand how that process translates through. So let's kind of talk through this. The PO is issued by the buyer and it's to be fulfilled by the vendor or the seller. And then that invoice doesn't come until after they've fulfilled, whatever it is, the service, the goods, and then it has to be paid by the buyer. Not all businesses, and this might be you, use a PO process, but even a small business, you can think about it, your accountant might thank you, but it helps track your purchases with your invoices and back and forth. Not always going to be applicable, but sometimes. So let's just walk through it. So the first step on the far left really is that the buyer is deciding to order something from the seller. Say, for instance, I wanted a new chair because my chair is broken. So I'm going to say, okay, well, you know what, the whole office or even just me, I'd like to get some new chairs. I'm going to draft a PO, and I'll talk about that on the next slide, what needs to be in the PO. And I'm going to send this to the seller for approval. Okay, so I'm going to send it. I'm going to say, I want, I've got my header, I've got their information, and I say, I want, 5 gray chairs at, however much, $100 a piece, and I need them delivered by this date, and it will be in like a line item, and it will come down. Then what you do is you send that to the seller. The seller is going to review it. They're going to look to see if they can fulfill the order, and then they will turn around and approve the PO, or they'll send it back to you and say, we can't do this, but we can do it for this much, or we can do it for that. That would then be a counter offer sending you back to the beginning of the list. But if they do accept it, then you have the fulfillment of the PO by the seller. The seller says, okay, I can ship these chairs to you within 30 days. I'll install them in your office, and I'll make sure they're ergonomically set up, whatever you have on that purchase order. Then after, either at the time of dispatch or at the time they're delivered, depending on how the PO is written, then, that would be when the order is fulfilled. Then the seller is going to send the invoice to the buyer. They're going to say, great, you got your chairs, you're happy, or even if you're not happy, you still got them. Here's your invoice. You owe me $500 for those 5 chairs. So then the buyer pays the invoice, and then the seller sends the receipt to the buyer. So it's a lot of back and forth, okay? And ultimately, that's where you get the contract. I also want you to remember a key difference, and this is just a little thing, but invoices are not bills and they are not receipts. So as it says here on the timeline, a bill is issued for an immediate payment. Think of that being in like a barbershop, hair salon, you going out to dinner, they don't do your hair and then say, okay, you can pay me in net 30, right? That doesn't happen. So a bill is something you pay immediately. A receipt is what's issued after the invoice has been paid in full. So in this case, you would make the payment and then they'll send you a receipt. All of these documents you would need to keep, and you would want to keep them together. So for instance, if you're a small business owner, and I don't know if you're using QuickBooks or you're using any of those things, or just using tried and true Excel and paper methods, I would keep all of those things together. The PO, or if you don't have a PO, an invoice, and then the payment, and then the receipt. So you can prove it out when you go to do your taxes. And that is not tax advice. That's just keeping all your documents together. Any questions before I get into what's specifically on a purchase order? Okay. So a purchase order, these are the basics that you're going to want. And there are plenty of very free and very useful templates out there. Being the lawyer that I am, I wasn't going to go look for one, put it on here and risk having, an issue with someone's copyright. But even in Word, I was looking around in Word, you can literally download these within any of these things and find free examples.
Hey, Beth.
Yeah.
I'm so sorry. It looks like Sean had raised his hand.
Oh, okay. Sorry, Sean, go ahead.
Well, I was going to type it out, but the question I had was with a PO is that in a services industry that I'm in, um, is is a statement of work very similar to a PO in terms of the legality of it that you're presenting here?
Yes. So your statement of work is actually going to be, it's going to be somewhere it's a hybrid. I would say it's more like an actual contract rather than necessarily a PO. It's going to be, to me, a statement of work is going to be more similar to like when you get into a vendor agreement. It just depends how detailed your statement of work gets. So if you're line iteming, because you're providing a service, you might have one whole block that says, I'm going to provide chemical analysis of these chemicals and it's X amount of dollars, and that's your line item. And then you can have additional terms that are underneath that right there on the front page of the PO, or you can have it more like a written out contract. And either way, that would be fine. So if you're the one providing the service, it would be the person you're providing the service to issuing you the purchase order. And that would be how they would go about it. But the statement of work, and I look at them all the time, especially for services, right? Those I relate more towards, depending on their complexity, more towards a vendor agreement.
Yeah, the approach we've had so far is the vendor will give me a statement of work. I'll use your example. I need analysis of these samples, and then what I typically have then performed is then issued them a quote to perform that work. They sign that quote, and I make reference to their statement of work.
Yes.
If it has a number or date to it, and then we take that forward.
Yes.
So I just in my mind, I want to insert statement of work for purchase order as I'm following you, and I just want to make sure that was correct.
Yes. Yes. You've got it.
All right. Thank you.
No problem. And so to Sean's point, what he's talking about, it's going to have types, quantities, and agreed prices for the products or services, kind of by line item, right? And depending on the complexity of what you're selling, that being a service or a good, it will differ. You're also going to have delivery date and shipping information. And to go to Sean's point about, a delivery date, and you might have time frames where you have for a service, I'm going to provide this service by this time, I'm going to do this on this date. Then you're going to have a subtotal, discounts, shipping, all of that. On a service agreement, you're not usually going to have shipping, but you can at least have all those other pieces of information. So this is your purchase order. So this gets you down that first step. So after this is accepted, then you're going to move on to your invoice. So you've now delivered the product, right? You now have, or if it's a service and you say, I want X amount up front, you're delivering a partial invoice, however it works in your situation. You'll notice that the invoice is going to have a little bit more, it mirrors the PO very much, but it also has some more information. It's got, again, the seller, the buyer, the invoice number, and the corresponding PO or statement of work is applicable. Again, it's going to have the types and quantities. It's going to have the delivery date and the shipping information, but payment terms. So the two big differences you see in this one are the payment terms and the invoice number. So you're always wanting to tie that invoice back to something prior if you can, right? But no matter what, you always need the payment terms, and you need to make sure this document is dated. It sounds silly to say that, but there are many times where people will send something out and it might, if you're not using a form, you might just send an invoice and it might not have a date. That's important because if your payment terms are net 30, you need to be telling the buyer or the person who's buying your goods or your services how much time they have to pay you. Okay. Does anyone have a question on this? No. All right. So what I want to get to next are your purchase order, invoice terms, and conditions. Many POs and they have terms and conditions on the front, or they're attached as part of the agreement. So these are often, they cover acceptable payment methods, product returns, all of those types of things you see there, and they're going to have other conditionals. So these are what add another layer to your purchase order terms and conditions. So what I always tell people is make sure to read the fine print. If there is a dispute between the parties on the performance of these form exchange, if you have no other contracts but the equivalent of this form exchange, the courts are going to look to the terms and conditions that these agreements were made underneath. Oftentimes we call that the battle of the forms, right? And so the court will go in, and depending on the jurisdiction, they'll look at it and say, well, they agreed on this, they differed on these, those get thrown out. We're going to apply our own law. So when they are issued, however, as part of a larger agreement that we're going to talk about in a moment, the T's and C's will be overruled often by that larger agreement. So say I have a sales agreement with you and I'm the vendor. It doesn't matter what's in the PO and the invoice terms and conditions. We've already agreed on a larger set of terms that we are going to talk to. And you will often see that written out in those notes on those POs saying, this is, subjugated to the contract that was issued on X date between the parties. So you see that in larger agreements, but always flip it over, take a look, and make sure. A lot of times now with things coming digitally, it'll be a second page. They might, send that, or you might not have any at all. And, I would look at, for your business, kind of what the thought processes are and what things you might want to be concerned about. If there was anything that you're doing that you want to say, nope, no returns. I only take, I don't take Amex. I only take Visa and Discover, any kind of things like that you can add. You can also even say, this will be interpreted under North Carolina law. It will be, if we have a dispute, it will go to, and you can name the county that you're in. All of those different things can be in the fine print on the terms and conditions. Okay. You also have sales and vendor agreements. So this goes to that next step. So imagine you have the purchase, those are the underlying commercial documents that are going to go back and forth. And they do create, an offer, an acceptance, and consideration. Now, when you want to take it that next step, okay, these contractual agreements are an expansion of your business from a transactional arrangement to a longer term relationship. They can offer you more certainty, but they can also lock you in. So there's pluses and minuses to them. And if you're going to have, certain types of agreements, remember, they have to be in writing anyway. But the contracts for these, I put a few of the things here that you might want to agree on, because you don't have to then go back and negotiate it every time. You don't have to go back and negotiate price, who's paying for shipping, where it's going to, depending on what it is. You might want to have a warranty. You might want to be indemnified, any kinds of things on that. Also, especially with the prices, that'll allow you to often set prices either on an outgoing basis with that customer or on a incoming basis from one of your vendors. That allows you to have a better planning for your P&L, basically. Does anyone have any questions on sales and vendor agreements? What I would tell you is they can be pretty complex. They're usually going to be, lawyers like to try to keep things concise, but they can be pretty long. I would caution that when you get a contract from, somebody else, always make sure you're looking over and you're paying attention to the sections that really will impact you and your business. If you're buying something from somebody and you're going to be using it on customers or for customers, you want to look and say, well, if I'm buying this from you, what recourse do I have if it ceases to work, if it causes harm to somebody? Know your supplier and know your customer, right? So those are all types of things. Another thing tangential to this that I won't go into in any depth, but when you're talking about payment terms, also think about whether or not you're going to extend payment terms or credit to a customer, right? Are you going to give them 15 days? Are you going to give them 30 days? Are you going to give them 45? How long are you going to give them to pay? Are you going to give them a discount for paying early? Are you going to give them a discount for paying in one way or another? All of these things can be mixed, together either in your T's and C's on an invoice, or they can be in a larger sale and vendor agreement. So it's really just, as you leveling through your business, what you want to do. I mean, we're a large business. I wouldn't say we're large, but we're medium, right? And what I would say is we have all of the above, right? We have some that are just transactional, PO, invoice, T's and C's. I have some that are sales and vendor agreements. It's really what you need for that specific vendor or that specific customer. Any questions? So the third type I wanted to talk to you about are waivers of liability. And, this is basically informing somebody about the risks associated with an activity. And they're saying, I'm not going to hold you liable for any damages or injury. And the common examples that people think of are, parking lots, outdoor activities like kayaking, going to spas. And as I was, getting this ready for you guys, I was traveling for work and I was on my way back into RDU, and I picked up my little ticket because I forgot to pay online ahead of time. And even on the back of this, on the little thing, it will have a waiver of liability, and it's referencing the terms and conditions. And it basically says that if vehicles are damaged or anything like that, then it's on you, right? You're waiving your liability, you're parking in our garage, and you're knowingly doing so, and here we go. So again, even a little waiver of liability for a parking at RDU can be an offer, an acceptance, and then a consideration where they've been paid, and then I'm waiving my liability to come after them should anything happen to my car. So with outdoor activities, you see this a lot with kayaking. If you are in a service industry and you're visiting people's homes, you're interacting with folks, you want to think about doing that. Mainly, you're going to think about things that involve a risk to property, personal or real property, finances, and health, right? So that's where you really usually want to look at whether a waiver of liability would be something that you would need. And last but not least, I wanted to touch on confidentiality and non-disclosure agreements. So it's really important to protect your information. There are many stories of businesses not adequately taking measures to protect their confidential information, only to find that another company has taken their invention or disclosed their confidential information, and they don't have any recourse. So as we get into it, there are two types really for confidentiality and non-disclosure agreements. They are unilateral and mutual. So in a unilateral NDA, that's basically one party agreeing not to disclose classified information. Think of this in like an employee context. I have a confidentiality agreement with work. I learn things by nature of being here, and I am saying I will not share that information outside of my workplace and with specific people. A mutual NDA is that all parties, it doesn't have to be just two, this can be multiple parties, are agreeing not to share any confidential information outside of that group, right? So this is, say you're in a discussion, you're trying to find out to build that statement of work or to find out what that customer needs. You're exchanging information, you're setting them up, you're onboarding them, you're getting their credit card information, whatever you're doing to get, them into your system. You're sharing information back and forth, right? And that's really where you think of like an MNDA, and that would be where you would want to make sure that they're getting information about you, but you're also getting information about them. This is used, as I said here, in negotiations, mergers and acquisitions, especially product sales or licensing, and inventorship, and any kind of investor discussions, right? Because you don't want someone to know, hey, come take a look under the hood at my business, and then they turn around and go use it against you somewhere else and go acquire somebody else. So Any questions on the confidentiality and non-disclosure agreements? Okay. All right, guys. Well, that brings me to the end of the presentation materials, but not to the end of being able to answer any questions that you might have.
All right, looks like Sean has his hand raised.
Yes, my question was in the mutual NDA, I've had to kind of bring that online because I've had clients come to me that, they might have a great idea and they want to start working on something. And I always like to cut them off and say, hey, let's put something in place.
Mm-hmm.
But I always feel weird about writing an NDA from my perspective. Like I always kind of feel like it should come from their perspective. Does a mutual NDA that I now currently have one, but does that protect them just as much if I'm writing it, I guess is my question.
So yeah, if someone has looked over it, they signed it, and they have understood the terms and they know what it means, it doesn't really matter which side wrote it. A lot of times with us, for instance, and I should have said this, like before, if it's more than just contractual, back or transactional back and forth, like purchase order, invoice, that kind of relationship for us, I make all of our sales guys, they've got to go out. And once you pass that like preliminary and you're starting to kind of exchange information about each other's businesses, absolutely, I tell them we need to go get an MNDA because we need to be protected and they need to be protected. So it doesn't really matter. A lot of times you'll see, like, I'll send an MNDA over, the other side will send one over. In general, it doesn't matter who it comes from as long as both sides understand it. And remembering too, you're not there to give them, legal advice. You're there to protect your interests. But with a mutual MNDA, in general, the terms are going to be mirrored to each other, unless, it really depends on the way it's written. But I wouldn't feel strange about giving someone else your MNDA to start off with at all.
Okay. I think the one side of that is, within many NDAs and this one in particular, there is a section that talks about the jurisdiction.
Mm-hmm.
And of course, it's my NDA, so I'm going to put North Carolina.
Yeah.
But I deal a lot about out of state and even occasionally out of country. And so that was kind of the angle I was kind of taking.
Yeah. So what I would say is, I mean, the first one to go always strikes first, right? So ultimately, all of ours say, North Carolina, right? Because that's where our business is located. And if someone has an issue with that, then you can go to a compromise, and then try to find a different jurisdiction, especially if they're international. You're going to want to be more in your home jurisdiction than trying to go hunt them down elsewhere. So it's easier. It's always easier when you're talking about it from your business's perspective to have it be there. And then it would be not only, jurisdiction being in North Carolina, but having to apply North Carolina law. That's always going to be in the best interest of your business, is to have it be, up first where you reside and where, attorneys that you could easily get to would be, comfortable with.
All right. Thank you.
No problem. Anybody else? Well, what I will say is, guys, I will make sure that Bianca has the recording of this. I know she has that. And then anybody who would like the actual slide deck, I'm happy to provide that. So I'll have the notes and you can see kind of what I've also said or thought that, so you don't have to remember it or write it down. You can have it as a reference material. And additionally, I'm always happy to, answer. I can't provide necessarily legal advice, but I can answer questions about contracts as far as the setup or whatever, or help direct you to the resources where you can get some information and some help. And if there is anything that you guys would like to see more in depth related to contracts or other parts of business, just, reach out to me or let Bianca know, and we can try to set something up and, see what we can do.
Yes, thank you so much, Bev, for all that great information you shared today. I actually learned a lot myself that I didn't know. And thank you everyone for attending and participating. This webinar will be available within a week on our website at ncbarfoundation.org. I would like to thank our program partners, Mount BizWorks in Asheville, Prosper and Climb in Charlotte, and the small business hubs at Fayetteville State and East Carolina University. If you have any additional questions, like Elizabeth said, please reach out to her or please reach out to myself by email at foundation@ncbar.org. That again is foundation@ncbar.org. Thank you all again and have a great day.
Thank you, guys.